Arise analyst and lawyer Frank Tete joins us now to look at this and help us make sense of it. Frank Tete, good to see you.
My pleasure.
You're welcome. So, I mean, you heard what IPAC, said there, and quoting, saying that the PDP says INEC is acting against, the Court of Appeal judgment, which said all parties shall contest in the rerun. Is there a misinterpretation or misrepresentation here? Who is misinterpreting?
I think there's so much subjective, proposition there. Everybody's saying what they wish should happen, different from what the courts and the law actually say. Now, it's unfortunate that Section 246, subsection 3 very unfortunate, of the Constitution says that the Court of Appeal decision on any matter arising from the tribunal with regards to contentions from National Assembly and State House of Assembly elections is final. Whatever decision the Court of Appeal makes is final. And the Court of Appeal says that the PDP, in fact, the Court of Appeal nullified the election for which there's going to be a rerun, that on the grounds that the PDP candidate that won didn't have a basis to win. He didn't have a structure. In fact, he wasn't qualified. He nullified his election. So clearly, you don't need any further interpretation to know that the PDP is not qualified to participate in the rerun election that is about to hold on the 3rd. Now, going further, the Supreme Court says that the Court of Appeal was wrong, and that the Court of Appeal did grave injustice to all of those members, particularly the PDP, that were removed as a result of that, misdirection of the law. The Supreme Court at that point also expressed the proverbial hands being tied, his hands being tied, that there was nothing he could do. So if we speak about the contention at the moment, is simply about that of justice against law, right. Which one would INEC follow? INEC must at every time realize that its independence is to help its impartiality. It must not in any way be perceived to be biased or in favor of any political party or any candidate. Now, will INEC pretend as if it's a robot run by a computer program, that it cannot, that is fixated, that it cannot realize that the Supreme Court of the land has declared the action of the Court of Appeal to be inconsistent with the law? Would INEC constitute itself into a court to interpret and then choose between the provision, the judgment of the Supreme Court and that of the Court of Appeal?
Well, INEC can be easily... INEC says we never, underscore that, we never flaunt any law.
Oh, that's not true. INEC, that's not true. INEC is making a mockery of the Supreme Court right now with regards to the case of Dozie Ojoku, who's the APGA chairman. There's a clear-cut Supreme Court decision on that. INEC has decided to make nonsense of it. So there are several other decisions of court that INEC does not obey. But in this case...
Yes, I wanted to stay on this.
Yes.
I wanted to stay on this.
Yes.
And it's got an interesting perspective because those questions you were really are not rhetorical questions. Those are questions that truly a lot of people will be wanting to hear Frank give his perspective on this. Assuming without conceding that INEC is saying, let's read it the other way. And INEC should read it the other way and say, a minute, let me just line on this and say, okay, they can participate. Would it be wrong of INEC?
No, I don't think so. INEC will be saying, look, it doesn't want to interfere. INEC would say that as a law-abiding institution that takes precedence from what the law says, and actually what the law is what the courts say it is. So if the Supreme Court has declared that the Court of Appeal is wrong, INEC would want to, at this time for once, send a note of impartiality and say, look, you can come contest and let's see what the courts will say. The worst that will happen, it will give the courts another opportunity to now to correct that notion that the Supreme Court deprecated seriously when it reprimanded the Court of Appeal for such reckless decision that it made.
It would be truly wrong for someone to lose twice, and in this case it would seem as if they're losing twice and unjustly so. Is there a way to actually stay action until such a time that the right thing is done?
You see, the first thing is this. We need to name business in this country, first as a people, and then beginning as politicians. So would the politicians in Plateau take advantage of this, technical error by the Court of Appeal? I think the IPAC is on the right course when it says, look, we can rewrite the situation.
Yeah.
If we now transcend above these these decisions of the misdirected decision of the Court of Appeal by choosing that all of us will participate or will not participate. Even though that is whimsical on the part of IPAC, it's quite unrealistic. It won't happen. The APC is poised to take advantage of the situation. In fact, it has started boasting a few days ago that it has already won the election because it is a walkover for it as a political party when the PDP is not there. But more especially when it knows that the PDP is actually popular. So how do you, face this conundrum when the people, this is, that this is, this particular candidate is what the people want, what they have voted for. And then all in the name of law, you defeat the essence of democracy, and INEC would justify that even in the face of an opportunity, an excuse that it could rely on the decision of the Supreme Court and allow some fair play and pretend that it is, it's impartial. So INEC has a very crucial role to play at this time by saying, look, we're a country that should pursue justice, because justice prevails. The law, the end of the law is justice. Right. And we cannot allow the law defeat justice. INEC can and indeed interpret the situation and allow the People's Democratic Party to participate in the election.
Doesn't it take us back to the fundamental issue of whether is it the ballot that should decide the outcome of elections or the courts? Unfortunately, it's tilting more and more towards the courts.
Yes, because that's the system we have set up. And the courts must now continue. And you can read from that, what we call the body language. I mean, it's an expression that is put in our political lexicon of the Supreme Court, that it may not want to tamper with what INEC has always done. So many of the cases that have come to the Supreme Court has treated them with a notion that of non-interference. So we are gradually moving to that jurisprudence where the court is now teaching itself that it is losing relevance, it is losing credibility, it is losing respect every day because of the decisions it takes on any political case that comes to it. Because political cases are charged cases, they are cases that are riddled with a lot of division. And see all the aspersions that have been cast on the court only on account of political cases. Therefore, we are moving seriously in towards the era of reform, whether reforms in security and electoral reforms, to the extent that we will see an INEC that will conduct an election and everybody will acknowledge that there is no point of contention. And then we will find a way to limit the interventions of the court. If it's possible, allow the Supreme Court to deal with only the election of the president, only if it is absolutely necessary, and with leave, not as a matter of rights that you can approach the Supreme Court. Right now, the court system is in an abysmal state. I listened to Justice Alilu today when I appeared before him. The man was literally crying because of the dockets of the Supreme Court that are full, and the idea that even the Supreme Court doesn't have dates to give to you if you approach it up to 2030. If you go to the Supreme Court, if you have managed to appeal to the Supreme Court today, the Supreme Court will give you a case for the date for hearing until maybe 2032. Just imagine that. So why would the Supreme Court look as if so justice is becoming a mockery, all because of political cases that have made nonsense of it in the eyes of the public?
Well, certainly breaks the heart of anyone listening to you now. But again, quickly here, in this or this error, I know lawyers, they try to run away from that word, that the Court of Appeal made an error in judgment. But again, in that, how can it be, forestalled or remedied? I'm talking about
remedied this particular case.
Because we're talking about people, at the Temple of Justice who saw this decision, which the country is suffering from at the moment. Shouldn't there be some kind of measures
to
deter anyone on that?
I agree with you. I'm a stickler to procedures. And one of the offenses, maybe a senior advocate of Nigeria or a judge or a lawyer can commit is when it misrepresents the position of the law to its client. In this case, the client to the Court of Appeal is the Federal Republic of Nigeria. What it has done is to turn the law upside down. But the procedure is this: you make a complaint. And in fact, it's a very grave offense when you, as a senior advocate, for example, you do not have sufficient knowledge of the law. It's an offense. It can amount to you being stripped of that rank. And then if you are a Court of Appeal justice, and in this case a panel of 3, now misrepresenting the law deliberately and then giving the impression as if it was influenced, you know, giving a very, very negative impression of the judiciary, the process is that simply they can write an application to the National Judicial Council and it will sit. Justice Walter Onoga is currently looking into such issues of conflict of judgments. You imagine the imbroglio, unnecessary imbroglio with regards to an Abuja High Court giving an ex parte order to the police to arrest a certain fellow in Rivers State, and another court then that's ought not to be. So we're expecting, in the answer, direct answer to your question, the National Judicial Council has a very tough task to rid the system of these inconsistencies.
We'll have to leave it there. Thank you very much, Frank Tietie, lawyer and Arise News analyst.